Weighing the Options, featuring Dr. Mark Lee Levine, CCIM, and Dr. Libby Levine, SEGEV, JD, LLM. Mark is a full professor at the Burns School of Real Estate and Construction Management at the University of Denver, Daniels College of Business. He has been a real estate broker, attorney, investor, and professor for more than 40 years. Mark is a 4-time Fulbright Scholar. Libby is a teaching professor in the Business Ethics and Legal Studies Department at the University of Denver's Daniels College of Business. In addition to her teaching, Libby is a licensed practicing Colorado attorney and real estate broker and has co-authored numerous publications. During today's webinar, you will have the opportunity to ask questions by using the Q&A feature located in the toolbar at the bottom of your screen. If you are experiencing technical difficulties, please use the chat feature. To ensure enough time is allotted to cover today's content, Mark and Libby will answer questions at the end of the presentation. A recording of today's presentation will be made available to attendees within 24 to 48 hours. Mark and Libby, please continue with today's presentation.
Well, thank you. Libby and I both thank people there at CCIM. Of course, thank all the folks at CCIM. I was asking earlier whether we got our paycheck, but I was informed there isn't one. So we're cutting this seminar down to half the time. Well, maybe not. Anyway, seriously, we're happy to be here, and Libby will be saying some things as we move along, but she's allowed me to go forward initially with the slides, and then she'll interject, and then she'll cover a lot of things on the questions and answers. So with that in mind, as you've already heard, we're really thinking about, well, I'm going to say in the negative, not discussing opportunity zones in some big depth position, but rather a contrast of opportunity zones and the technique that most CCIMs know, the 1031 issue, the exchange issue. So we will contrast those, and we'll also add in, of course, the typical sale issue. So you might think of 3 things. The sale, of course, is always out there potentially, but then we're talking about the new opportunity zone issue, which we'll get to in detail, the 1400Z of the Internal Revenue Code versus 1031 of the Internal Revenue Code, which has been around a long time. So we'll get to all those things. Again, there are lots of articles out there. You all, as CCIMs or candidates, certainly have heard and read a great deal, I'm sure, on opportunity zones since its passage at the end of December in 2017 in the Tax Cuts and Jobs Act. It's been a hot topic, but since there's so much out there, that's not our purpose today, per se. We want to contrast opportunity zones with 1031. So we're assuming some basic knowledge in both opportunity zones and 1031, and then we'll go forward. Since we have a CCIM audience, I think that's a fair assumption. So we'll move forward from that standpoint. All right, so you've already heard I'm the old guy, and this is the young, good-looking girl, lady, I should say. That's my daughter, I can say girl, but Libby's only been practicing for about 15 years in law and teaching and so on.
And they don't want to hear about me, so we're going to move on to the next slide.
Okay, so I'm delighted to do this with Libby, and those of you who know Libby know she's very talented, so I can say that much before I move on. All right, so let's get into the material, which is, again, what I've just mentioned. It's some choices. We always have that as CCIMs for our clients, for ourselves. We can sell it, we can exchange it, and now we can potentially invest through a qualified opportunity zone fund. So that's where we are today. And by the way, we did do an article on this, which I think is out now to the CCIMs in the journal or the magazine. So you want more depth on that, you can see some references there. We also have done a much more detailed article than one occurred in the one we presented in the CCIM magazine. So there's lots more to say, and if you want more from us, then you can reach us, and we're happy to try to help as CCIMs. We're always happy to try to do that. Or I'm a CCIM. Libby, if she just wind up a couple things, we should be finished with that. Anyway, let's quickly, we're not going to sit there and talk about details on exchanging. We're assuming you're familiar with it, as I said. We will talk about a little more on qualified opportunity zones and then tie all this in with the contrast. That's our goal today. So just to emphasize the 1031, and that's what we're going to do. We're going to contrast it by looking at some changes, yes, on each of these areas, but more so the differences of using a 1031 versus a 1400Z or the qualified zone fund. We all know that 1031 was changed recently, eliminating the ability to do a tax-deferred exchange. I'm glad there's no period there. Tax-deferred exchange of personal property as opposed to real property. So we all know that it's been discussed to repeal 1031. Well, it still exists. Thankfully, it's been around since 1921. I'm thankful for that, since we have a few books out on exchanges, and I wouldn't want them to all be wasted. But we can only exchange real property under 1031 and not personal property used in a trade or business or investment. So with that difference, and why do I point that out? Because the qualified opportunity zone allows for investing in personalty as well as realty. It's not restricted to realty, which the 1031 position is. So there's one difference right there. So if you have a furnished apartment building, for example, no longer can we do an exchange of that as to the personalty in it with an exchange of other trade or business or investment property. But under the opportunity zone, it's possible to invest and have that as qualified property. But again, we'll come back to that in a minute. And again, you have a chance for questions. So here's one change. Well, it's not a change for 1031, but it's a consideration. We all know under 1031 for exchange that you have to exchange out of property that you've been holding for trade or business or investment. And when you go into other property, you have to acquire it with the intent and the actions of holding it for trade or business. That means, of course, the property needs to be acquired not with the intent for resale of it. So the example on the screen shows that X owned a property, X1 we'll call it, and was going to do an exchange with Y, and what straightforward, easy deal. And Y's got the Y1 property, so they exchange with each other. And excuse me, this would not be a qualified 1031 exchange for X if X had held the property primarily for sale in the ordinary course of business. So we have to make the assumption to qualify under 1031 that the disposition of your property and the acquisition is property held for trade or business or investment.
And if I can just add in here that I think this is an area we find that a lot of people have confusion or sort of ignore the intent. It's really crucial that the intent is not to fix and flip or to be a dealer and to have the intent to sell it immediately after, or even holding it for a little while.
Oh, good point, Libby. And what we're saying there is, of course, also as an example, if Libby's building houses for sale, she could not do an exchange. I think we all know that. For, let's say, an apartment building and exchange some of her houses she built for sale. Likewise, the opportunity zone also looks to held for, you cannot do hold for sale. You have to hold for trade or business or investment. So that one's a consistent position. And it's a good point that Libby emphasized, because we say in our law practice or whatever settings where whatever hats we're wearing, brokerage hats and so on, that people tend to forget that this issue, that of course you cannot be involved in property that is held primarily for resale if you're trying to do a 1031 or an opportunity zone investment. Now, quickly, here are a few questions that we always like to ask on a 1031. They're relevant for our contrast today, so we're not trying to be too basic here, but there are important points and also consideration of a sale. First is, of course, the only reason we're playing the game we're talking about today is for ourselves and our clients. We are saying if you're going to generate a large amount of gain, because we're talking about gain here to defer the tax on it and, of course, potentially exclude it, we'll get to in a minute. So we don't want to have a situation that we're going through this brain strain for a small amount of gain, whatever that is. That's relative to you and your clients. You'll talk about that. The same point is true, however, you wouldn't bother going through an opportunity zone fund per se to defer income if you don't have much income. Okay, that's pretty basic. And these are 4 questions we always ask relative to exchanges, but we'll ask them with the opportunity zone. If you have gain, great, but you have tax. We all know that you could have gain, but maybe it's sheltered by other depreciation or a write-off or carry forwards or whatever. So if you don't have a lot of tax to pay, you can define that number, then why have the brain strain? Why not just sell and use the funds you want? Do you want out of the property? We always ask that question as CCIMs. You got to have a client that wants out of their property, of course, because if you don't want out, we're not talking about either one of these things, opportunity zones or exchanges. And of course, you got to want in. You must want in another property, and that's true on the exchange side. It's also true on the opportunity zone. We all know that somebody who says, I just want to take my money, put it in the bank, put it in cash, and so on, I'm retiring, that doesn't fit the exchange mode. If you say the same thing on the qualified opportunity zone, the same issue. Do you want in other property? Now, true, you could be in more of a passive level kind of structure because you can invest in a qualified opportunity zone. In fact, that's what you're going to have to do, as we'll cover in a minute, if you want the deferral under that rule. But you have to want to do that and willing to do that. So X is coming out of property. They don't want to be in general properties. They want to go into a fund. Great. You're perfect for that. Okay. Now, as I said, we're not going to spend a lot of time on exchanges. We're going to contrast these. So the opportunity zone and the deferral. So we've just talked about 1031. We know those rules pretty well, I'm sure. Now we're saying here's this new set of rules under 1400Z of the code, and we do have some proposed regulations out that help us a great deal, but there's still many questions. So I'm going to preface everything we're saying now by that point. There's questions you're going to ask, and we're going to say, don't know the answer. Maybe should, don't know. So if we do that, forgive us, but there are lots of questions in the opportunity zones because it's so new. Liv, were you going to say something?
Yeah, I just wanted to add that that we've talked obviously a lot on this and a lot about the fact that this seems to be sort of a test, that the government is kind of testing this idea of opportunity zones and how it'll work. And there's a lot of speculation as to how it might change. Of course, we don't know the answer to that because we don't have the crystal ball. So I think that's important to keep in mind as well.
Okay, thank you. And again, that's our hedge, admittedly, but there are lots of things we don't know the answers to. We know a lot more since October of 2018 with the proposed regs, but there's still lots of things to answer. And even the proposed regs say there's another set of coming out. So the opportunity zones, again, are new creature, as mentioned on the screen, and we'll move through some of the things, but not everything. We all know that the purpose of an opportunity zone was to encourage economic growth and investment in, quote, distressed areas. I say, quote, because it's entirely possible that the opportunity zones might not feel as distressed in some jurisdictions. There's about 8,700 opportunity zones, as I think many of you know if you've been reading about this. That's a lot of zones. States are talking about up to 25% of their area as labeled as opportunity zones. Of course, that has to be confirmed by the Secretary of the Treasury, which it was, and we've got somewhere in the range, as I just said, 8,700 zones. Some smaller and larger, but anyway, with these, the theory is to stimulate growth, and we have some areas, I'll just say, we're in Colorado, so we have some areas in the Denver area, we have them in Boulder, other places. We're saying, wait a minute, are these really these distressed areas where they're poverty areas, where there's issue about needing some economic stimulus? We're not going to sit here and talk about that very much. We already know, if you read a little about this, and I think there's a lot of flexibility in the areas. Liv, you're going to?
No, I was just going to add that I know you already mentioned that up to 25% of the low-income areas within the state. But again, with the intent there, as we see it, that the government was trying to stimulate the growth, there is a special rule within the code section that provides that areas, low-income areas in Puerto Rico are automatically deemed to be opportunity zones. So I think that goes to the intent of what they're trying to do, but I think it's fair to recognize that that might not be the case in all of these, jurisdictions.
Sure, there's a lot of places that seem pretty nice, and you say, well, it's great, I'll go into that area. Leaving that issue, knowing that's the intent, let's move forward. You, as our clients, we personally investing in these areas can elect to defer. Remember what you're deferring. Under an opportunity zone, this is an important contrast with 1031. Opportunity zone, you're deferring the gain that you generate when you sell, let's say, $1,000 worth of stock, and you have a gain of $100 or something. We're going to go through a few examples a little later, or it could be 10 million, whatever the number is. You're talking about deferring gain. So 1031 tells you basically you need to reinvest. I'm going to say it broadly. Forgive me, CCIMs. What you sold it for. It's not completely true, but basically you got to invest the whole thing, not just the gain. Opportunity zone is designed to say all you have to do is reinvest the gain and up to the gain, and you can therefore not pay tax. So in the example I just gave, if you have a $1,000 sale, you got a $900 basis, you have a $100 gain, all you have to do is to defer that gain is to invest the $100 qualified in a 1400Z zone. And again, we'll say more with some more examples in a minute. I'm sure you'll have questions at the end. So why do you invest in the qualified opportunity zone? There's really, however you want to label it, you can call it 3 reasons or 4 reasons. But the first thing is you want to defer. Okay, so my example, selling stock, this example says at a gain of 1,000 instead of a sales price. But what you want to do is defer the tax on the gain. And we want to do that in a 1031 as well. It's just that 1031 forces us to do more. So here's the example. You go out, Libby sells a property, and she generates 1,000 of gain. It could be 10 million of gain. If she will reinvest that gain portion, not the whole sales price, and it's otherwise qualified in the zone fund, then she can defer the gain. So that's one big reason we all know we and our clients are thinking about this. Again, if you don't have a big gain, why in the world are you worried about going to it? Just make the sale, pay the little tax or whatever it is, whether it's, remember, we're talking about capital gain, and we'll come back to that in a minute. But if that's at a 15% at most or 20% at most, depending on brackets, it's not as big an issue as it is where we have more zeros involved in the amount of gain. And for that matter, if you had some ordinary income, but that's not what we're talking about. We're only talking about capital gain, because if you don't know it already, the only thing we can defer under is capital gain, and we'll come back to that in a moment. So if the taxpayer invests the gain, then besides deferring the gain, they put a couple more sweeteners in, and this is the exclusion area. As you see on your screen, there's 2 potential exclusions of the gain that takes place prior to the investment. That's important, investing in the qualified opportunity fund. What does that mean? Well, if you sold and you had a gain, then if you hold it at least 5 years into this new fund, then of the gain that already occurred, that's the 1,000 in our example, that you can take 10% of it off, or said differently, you're going to get a basis of 10%, so that your gain, if you had a basis of 10%, there, $100, your gain would be 900, so you defer 10%, or I'm sorry, you excluded 10%. So in addition to your deferral initially, you have a potential, if you hold at least 5 years, to have an exclusion of this 10% of the gain. If you hold at least 7 years, then you will have a basis of 15%, so you've reduced your gain down to, in our example, $850, because 15% or $150 of the gain. Okay, that's the second big group, or you can call it 2 things if you want, 2 types of exclusions. And the third one here is the gain that, and this is very important, the gain that generates after you've gone into the qualified opportunity fund. So the first thing is, you got some gain that you don't want to pay tax on. Forget the opportunity fund in general. say, oh, wow, can I get out of some of that? The answer is yes. If you'll go into an opportunity fund, then the gain that's already occurred before you've gone into the opportunity fund could potentially be eliminated up to 15% or excluded, however you want to say it. But once you go into a fund, if you'll stay in the fund at least 10 years from the time you invested in the fund, and we'll do another example in a minute, then the capital gain generated since the time of investing in the fund, if you meet the requirements, which is 10 years and some other things, then you can exclude all of that gain. So we've got two pieces of exclusion. We've got the gain before we got into the fund and the gain once we come into the fund. So we have some real nice carrots hanging out there to encourage our clients and us to go into these opportunity zone funds if we can meet the requirements, because it's tantalizing to think we got to defer the gain and now we get to exclude a lot of the gain. Okay, I hope we didn't skip anything because the screen blurred there. Thanks. Now, the next three slides just illustrate a couple points that, are in the regs, but came out in a, I thought, well demonstrated in an article, and I mentioned it there, we've mentioned it. You can invest on a direct structure, as it's sometimes called, and I don't want to get too far off into this because I don't know that it matters for most people. So I want to just make a few contrasts. You could directly, as it says on the screen, invest. So you could form a limited partnership as an example, and most entities will work, corporations, LLCs, so on. So you could form an entity, and then your investors are investing in it with a general partner, and then you go into a qualified opportunity fund. Now, this is very important. You cannot take your money. So if Libby, again, using her, sells a property and makes this gain of 1,000, 100 million, whatever it is, and she said, gee, I don't want to go in with other people. I think I know what I'm doing. I just made a lot of money and I want to control it myself. This is a disadvantage with, I think, disadvantage. Some would say an advantage if you got the right people, but with a qualified opportunity fund, because you cannot just invest by you going in a proper zone, an opportunity zone, and buy a property. That doesn't work. You have to go through a qualified opportunity fund. You say, okay, can I go create a fund? Well, there are thousands of these funds that have already been created because people have wanted to do that and are desiring the control, and so you see more of that. So your clients might go into some fund, but they have to understand they can't do it like a 1031 and say, okay, I'm just going to exchange out of this property into this other property because I like controlling my own destiny. I like to decide when I sell it and when I don't, and I want to manage it and so on. That's not the game here. You have to be through an opportunity fund. Now, some of you may have already started opportunity funds, great. But in general, our clients will not be in this setting. So they could direct structures, it said. You can go in an indirect structure where you invest is the same way, and then that entity invests in another entity, which goes into the qualified opportunity zone fund. I'm not going to try to do until questions more on this right now, but the point is, and the key issue is, I think, that you need to know that you, or your clients, our clients need to know they don't control the typical kind of real estate investment here. They're going into a fund. Think of it as a stock deal, a REIT, a this or that they know they put their money in, and they're passive. They sit back and somebody else controls the game. Unless you're going to create your own fund, which is the minority of our clients. So absent that kind of setting, again, they have to recognize this limitation and the flexibility that 1031 offers, more so that I could exchange my shopping center here because I'm leaving Colorado and I want to move to Florida and I'm retiring and I'm going to go down there and pick up a property down there. Maybe another shopping center, but it may be an apartment building or something else, and I'm going to control it because I want to manage it and do it. Fine. 1031 lets you do that. Opportunity zone funds don't let you do that the same way, as I've already stated. Now, what you see on your screen here is what the regs talk about and it's been brought up in a number of articles and things, but it's a good example, I think, to illustrate what we just said. And this is the key part. This is the tantalizing carrot that's put out for our clients and for ourselves. So they give an example that on January 1 of 2019, the taxpayers sell assets and they generate $100 of gain. Now, it could be 100 million, but it's just gain. So now you've got your sale, and you're going to have to pay tax on this 100 million, $100. Then, within the 180 days, and that's why it says that parenthetically, because that's the rule. I think most of us know you have 180 days. Let me just stop on that one for a second and say that 1031, as we know, requires a simultaneous exchange, X for Y, Y for X, thing generally, or you better make sure you comply with 1031's timing rules for a non-simultaneous exchange, which we know if I transfer my property to Libby and I don't want her property back, I want something else, I have to go out and identify the property that's going to qualify within 45 days of my relinquished property transfer, 1031. And then, generally speaking, we say close it within 180 days of my transfer of my relinquished property. I better get my replacement property back, probably with an intermediary involved and all the rest, which we won't go into now. And of course, when I do that, it's 180 days or the time for filing the tax return, including extensions if applicable, whichever sooner. But we usually don't add all that other garbage stuff, language. We just simply 180 days. Okay. Well, the same 180-day concept applies in a qualified opportunity zone, but you don't have to worry about intermediaries, because if, again, somebody X sells his or her property, they can take the cash, not like a 1031. You don't need the intermediary. You don't need all that, which, by the way, we've advocated for a long time. Just like 1033 of the code, when you have a condemnation of property, you can take the cash and reinvest in 3 years, or other involuntary conversions, 2 years, all those rules we've studied in the CCIM program. So you can do that. But here, you get a taxpayer who wants to go in an opportunity zone, is qualified, meets the requirements. You could get out of paying this tax, that is, defer it, the $100, if, as the example shows, by June 30th, you turn around and you, in 2019, reinvest properly, then you get to defer that gain on the $100, which is good news. And of course, now the exclusion application. If you hold that at least 5 years, which we've already said, so I won't beat that to death. But again, you've got till June 30th, 2024. Why? Because that's the 5 years after the time that you, again, invested. You've got 5 years or more. We'll give you 10%, says the code, meaning that you don't have to pay tax on 10% of the gain. What gain? The $100 example. So now you're down to $90, because it gives you a basis of 10% of that gain, which is $10. So it works out that you defer 90, or you defer $90 and you exclude 10. If you hold at least 7 years, which again starts at June 30th, in the example, then by 2026, you held it that long, then you could get to 15% using the same application of approach, so that you pay tax on only $85 that you deferred, and the other 15 you're excluding, not paying tax on. Now, you got to draw a line. It would be nice if we had one down the screen. I guess we could have. And we'd say, wait a minute. That's the stuff that happened before you got a deferral and you excluded before you invested in the qualified opportunity zone, or it occurred before then, let's say that, and then you held it for the 5 or 7 years. Now, if you've held up to 10 years, which again, would now, in our example, since you invested June 30th, 2019, we go to June 30th, 2029, and if you held at least 10 years, then all the gain occurring, crucial, occurring once you invested and forward, then you get to exclude that gain if you're otherwise qualified. You don't pay any tax on the appreciation once you got in the qualified opportunity zone. The $85 that's still going to be taxed, yes, but gain occurring after you invest in a qualified opportunity zone, you don't have to pay the tax on. So that's very attractive. And again, is that good news or bad news? I don't know. I mean, your client's got to understand that he or she's locked in, or we are, if you want these benefits for 10 years. Is that good for the market? Is it good for your clients? I don't know. You could talk that over. No one knows the answer to that for sure. You give all kinds of scenarios and do projections. Libby, you want to add something there?
No, I was just going to add, you said projection. I think the other thing to keep in mind is under this you have to say what changes will be made once it expires, if they'll let it expire, what's going to happen. So I think it's really important to understand that right now we know you have to be until 2029, but we really don't know what's going to happen with the law.
Good point. And you know, again, not only are you or clients locked in that way, but they did an interesting thing, different than 1031, which came about in 1921, modified heavily in 24, and a few other major changes as we know, but it's been around, and they passed the law and they kept it. Here, they put a ceiling on it, or a time frame that Libby's already just mentioned, and we'll mention more on those limits in a little bit. So yes, I mean, Congress can always change the rules, but here you've got some built-in considerations because you've got some ticking of a clock that's going on to tell us how long we can do these things. Okay, now let's quickly get through a few more things so we can answer questions at the end here. But a sale or other taxable dispositions are always the issues. So again, contrasting the three things. We've already contrasted. We're going to name just a few more items here very quickly and make this comparison of sale, exchange, or the qualified opportunity zone. So when we are contrasting this, we might contrast a number of things, some of which we said, some we haven't, but we'll just add to a little. Again, 1031 doesn't require a reinvestment in a given specific location as long as it's not foreign, as we know. So in the United States, you can go from Colorado to California to New York to whatever you want. Even though there's 8,700 plus zones, you still have to be in a qualified opportunity zone. So that may be a restriction that works or doesn't work for your client. The structure of the 1031 requires, I think, a pretty good deal of formality in some cases, especially the 45, 180-day rule, the use of intermediaries. Watch out that you don't have some problems with related parties, although related parties even applies in the qualified opportunity zone. And you've got to meet all the requirements. You've got to meet them in both 1031 and qualified opportunity zones. But you have to think about it. Remember, qualified opportunity zones allow for you to go to a business. That's trade or business. It's not just real estate. 1031 is just real estate, no personal property. So you could be in a butcher shop in a qualified opportunity zone if it met those requirements. I say you, I mean the fund. 1031 requires the investment in trade or business. Okay, 1031 restricts it that way. The qualified opportunity zone is talking about investing within those areas, and we're going to talk about capital gain in just a minute, and that's a little bit different point. But let's just run through these others quickly, and then we'll do that. General rule that one transferring the relinquished property has to be the same one with the replacement. You kind of have this in 1031, I'm sorry, in the qualified opportunity zones too, but I think there's a little more formality under case law under 1031. The party who gets out of the relinquished property needs to get the replacement property. Okay, there are direct exchanges and then qualified intermediaries. As we said, you don't need a qualified intermediary in the qualified opportunity zone. You could sell a property, make $10 million. You got these 180 days to get into the fund, and you can have the cash and so on. And remember, we're only talking about the gain. We're not talking about the whole sales price, which is a big difference between 1031 again. There are other requirements in both as to keep the qualified opportunity zone qualified, and 1031 has some other things too. So, you know, we have some other issues, but let's just stop a minute and talk about this issue which affects both of these choices to a degree in this sense. the new 1400Z, this code section that deals with the qualified opportunity zone, says that you can defer or maybe exclude, we've been through that, the gain if it's capital gain. And that raised some interesting questions. The regs have now seemingly quashed part of the concern. I know when we first looked at it, we were very concerned because it says when you sell, you have to get capital gain that's deferred. So let me give you an example. You sell an apartment building, or your client does, and you have a nice gain, and you want to sit there and defer that gain or maybe exclude some of it. And we've been through all that, but it says, okay, you can do that under a qualified opportunity zone if your gain is capital gain. Well, is it capital gain? We know the distinction of CCIMs between a 1221 capital gain general and a 1231 gain. 1231 meaning, of course, the trade or business property that you sold that is not really capital gain. We treat it as capital gain. We know that if you meet 1231 and you have a gain, if you have a loss, you get treated as an ordinary loss. You remember those rules. But it's not technically capital gain. So we were worried when we first read it, does capital gain literally mean capital gain in the proposed regs? Now they've said, well, if it's treated as capital gain, so I hope their reference, they didn't say it very specifically, meant to soothe our concerns and say, yes, as long as it's treated as capital gain. But let me give you the further example. You sell that apartment building and you have some recapture. Now, is the recapture treated as capital gain? Under the law today, we say it's still capital gain, arguably. It's just taxed at a higher rate on recapture, 25%, instead of what may be a 15 or 20% rate for federal. So I think the answer is it's okay. I would like them to spell that out a little more. That's just me. I'm a little concerned because I'd hate to advise a client that it's okay on a qualified opportunity zone that they'll be able to defer their gain of $2 million on the sale of an apartment building and then find out that it's not treated as capital gain. I don't think that will be the case, but I'm just raising the point, or we're raising the point. Okay, now, a couple other quick things and then we'll stop for a question. Whether it's a sale, exchange, or qualified opportunity zone, cash has its advantages. We know that. I don't have to sit and spend a lot of time on that. So you have to give up the control of that cash, at least as to the gain portion on the qualified opportunity zone. The immediate taxation versus the deferral and the assumptions you made, Libby's already referred to that, and we all know you're making some assumptions on your projection. So you've got to say, you know, on either 1031 or a qualified opportunity zone. The exclusion of the gain is what I was just mentioning, whether you can exclude or defer. And again, they talk about capital gain under 1400Z, where 1031 doesn't say the words capital gain. It just says you have to hold the property with the intent to involve in your trade or business or investment, which could be, it seems to me, 1231, no problem. Okay, timing and flexibility are issues. Does this timing work? Your client has to understand that that qualified opportunity zone may dispose of a property, and that may raise other issues for them that they're not happy with. The areas for investment we've already covered, so I don't think we have to say any more on that. It's a little broader in some ways for the qualified opportunity zone with personality, but we won't have to repeat that. And then again, controlling the investment. Who controls the investment? Well, the answer is your client doesn't. I mean, once they've invested, the qualified opportunity fund runs the ship. So that's a consideration as opposed to the exchange. A few other quick things. Management, we've already said that. How about anything to do with refinancing, dealing with others in investments you may not want to do, your client may not want. This one is big. Timing of dispositions and acquisitions, again, in a qualified opportunity zone, you don't control it. If you've done an exchange, tax-deferred exchange, and 5 years, 2 years, whatever, later you say, I think I want to dispose of it, that's up to your client. But the opportunity zone is a different thing. And control over decisions in general. So I think those are some of the concerns. There's lots more. In conclusion, the choice is important. Flexibility is important. Obviously, we got to think about that. And excluding income, sometimes I think we're so busy trying, and it's terrible for Libby to say this and for me to say this as tax attorneys too and real estate attorneys, but sometimes the tax tail wags the economic dog, and that may not be a good thing sometimes. Tax is important, but you got to weigh it in context of the whole position. And an outright sale may be better. I'm not advocating, nor is Libby. We're simply saying that there's no absolute answer. So, having said those points, I think we can take a few questions before we're finished, or I hope we can.
Yeah. We have some great questions here, and I think maybe you want to address, there were 3 questions on recapture,
Okay.
and I know you addressed those, but maybe making sure we got all of those. So here's one.
Okay, all right. The one question says, does current guidance include gain deferral and the recapture, straight line depreciation? That's a very good question, and we've already referred to that the concern is that when you sell this apartment building, technically speaking, I think you could make the argument, but I don't know the answer. I'm going to start with that. And I think Libby and I share that. We talked about it. So I think it's clear that recapture is capital gain, but taxed at a higher rate. So you can make that argument, hey, it's capital gain. On the other hand, a little differently with recapture on personalty, and of course, is different because recapture on personalty says you'll treat the gain as ordinary income to the extent, limited by the gain, but to the extent of the prior depreciation on personalty. So I think you got a problem, or we would have a problem on personalty as opposed to realty. We got a case to make on realty. So I don't know if I can say much more, but I think it's a great question. Okay, and 1240 and 1250 or 1245 recapture, I think I've just tried to say that. I think there's much more a problem because of the way it's stated on personalty, because it's treated as ordinary income. Okay, Libby, another one. I got to hurry here, right? Okay, what else? Yeah, we got that. Give me a. Is there a minimum time period an owner needs to own a property for it to qualify for 1031, not be deemed acquired for sale? Very good question. The answer is there's nothing stated in the statute nor the regs on minimum time. The government has argued that sometimes. There's a case called Wagenson in which the taxpayer was an old gentleman, I'll say it quickly, who acquired a property, held it only on an exchange, held it only approximately 9 months, and then gave the property to his grandkids and kids because he was an older fellow and wanted to do some estate planning. The government challenged and said, since you acquired the property for retransfer, it doesn't qualify under 1031. He said, what are you talking about? I didn't plan it. And he said, well, you only held it 9 months. He said, well, the statute doesn't say that you have to hold it in excess of a year or anything like that. And the government argued it was not qualified under 1031. The court disagreed. And so the answer, I think, is nothing in the statute, but we have some case law that supports a position that although we as CCIMs often tell people hold it at least over a year, because we're now analyzing and analogizing to capital gain holding period, there's nothing in the statute for it under 1031. Okay, one more here. Oh, I hope they don't cut us off here. Does an investor fulfill the requirements of 1031 exchange by using a qualified opportunity fund investment as the upleg in the exchange? I have seen some discussion about combining 1031 and the opportunity zone if it's real estate. But remember, 1031 requires you to invest in other real estate. And I don't think you're investing in other real estate, certainly directly, because a qualified opportunity fund is stock or partnership interest. And under some other case law, the answer would be no. Some people may argue that, oh, it could be broadened because you look through that. I would, at this point, maybe I'll be too cautious, but at this point, I would tell clients that I don't think you can replace on that and feel comfortable. But again, I may be wrong, and other people may be saying it's okay. I could give you some reasons to support what I've just said, but I'd love to see the regs come out and say, yeah, if the qualified opportunity zone is in real estate, then it's okay. But again, qualified opportunity zones can invest in other things than real estate. So I think it's a problem. Liv, you want to add, or you want to
No,
add your question?
I'll just take this next one while
Yeah,
you're looking at
go ahead.
it. So the question says, if an investor acquires raw land for residential development in an opportunity zone, what limitations do they need to be aware of? And I think a few things, of course, first and foremost, if an investor is buying the land itself, it doesn't matter that it's in the opportunity zone to take advantage of these rules. As we've said, they have to go through an opportunity zone fund, a qualified opportunity zone fund. But if you're asking if just somebody happens to own land in that area, I think one thing to be aware of, something that we've seen, there seems to be a trend, and obviously we haven't checked everywhere, but there seems to be a trend in a lot of these areas that there's been appreciation in those opportunity zones because I think there's a recognition that people are coming in and are investing through the funds in these areas, and so we've seen appreciation. So I guess that's something to be aware of.
No, I think you're right. The property and opportunity zones have moved up, but that one more point on the one that Libby just raised, that question. Don't forget, if you acquire property for residential development, it won't be property held for trade or business or investment. It's probably dealer property.
Right.
And if it's that, it's not going to work on a 1031. It doesn't work on an opportunity zone. So I think that's a problem. Now, we may have a problem because of our time, so I think we better stop and ask Angela and Jen and anybody else there for the CCIM office, do we need to stop? Are we okay? What do you want us to do?
Mark, it's Jen. You still have about 9 minutes on my time, so you can keep answering questions.
Okay, good. We're happy to. I think I told us at 45 minutes, so fine. We'll just keep answering as fast as we can here. The next question is, what about 1031 rule of not reducing debt? Well, there is really not necessary. Well, there is a rule about 1031. This is not opportunity zone issue. This is just 1031. About 1031 rule of not reducing debt. You can reduce debt, as contrary to what people generally say. You got to go equal to or up in debt. But as long as you're adding cash, that's the equivalent of it. So you can still qualify under 1031 even with the reduction of debt if you add cash. That's one way. So, okay, I've answered that, I guess, for now. Next one says, when a landowner sells his land for $5 million to a qualified opportunity zone and his capital gain is $2 million, can the landowner reinvest the capital gain of $2 million into the qualified opportunity zone as a junior, or as JV partner, sorry? And it said, he said, I heard there's a 20% limit rule and would like to get a clarification. Well, first, you got to be careful of a lot of things in this example. I think you've got step transactions, related parties. It could be. I'm not saying there is this. You've got a lot of issues. I am not sure on the 20% limit issue. I just looked at the regs before we started this, and I didn't remember anything in the regs on that. But if there's anything there, Libby's double checking right now on it. But I would be concerned. Let me say it this way. There could be an argument that you didn't really sell the whole thing. You sold part of it that you got out of. You're getting out of property on one side, and then you're taking the gain and going into another property. Forget it was this transaction. In other words, you just take the same thing they told us. A landowner sells a property for $5 million to a qualified opportunity zone, but he could sell to anybody. So he takes the $5 million, he or she, and has capital gain of $2 million. Can they then, in general, go out and invest in a qualified opportunity fund? Answer, yes. The concern is that it's in the same fund that just bought. And I'm not sure that that would be treated as a sale in all cases, and I assume that's where the 20% discussion comes from. But I'm telling you, Libby's looking to see if she sees it. I don't remember it on that, so I guess I better hedge that away and say, in general, I think you can sell and reinvest the money under the rules we've already discussed today in a qualified opportunity zone and defer the gain, maybe eliminate some of it as we've already discussed. But because it's in the same one, that alone raises an issue, which I would have to check and live. And the second point is, this question says, as a JV partner. Now, that may be an issue because, again, remember, there's limits on what you can do. You go into Qualified Opportunity Zone Fund, but that's different than saying you're a JV partner. So I don't know the answer. I'm just going to leave it at that and just say, I'm sorry, I don't. We'll do some checking on it. And if the party raising this question would like to send us an email, we'll come back to you on that after we do a little bit of checking. So with my apologies that I told you, we couldn't answer everything, and this is one I think we should hedge on. Libby, you found something?
I'm not saying anything in the meantime, but we can see what you said.
Okay, go ahead, Liv. Okay, and again, our apology, we'll come back. If somebody writes us, we'll be happy to. You've got our emails. What about, here's another question, what about added gain during a 5 and 7 year period? Well, there's 2 points, which we maybe didn't make clear. During the 5 and 7 year period, those were the 5 and 7 year period were important for gain that already occurred at the moment of time in sale before you've gone into the qualified fund. So that's where you get the 10% and 15%. Now, this question said, what about added gain during that period? That's okay. Meaning, once you've invested, as long as you'll stay in at least 10 years, then you have the benefit of a total exclusion of the gain occurring since the time you invested in the qualified fund. So I hope I've made it clear now. So whether it's in the 5 year, 7 year, but that doesn't get you anywhere except for the prior gain. It only gets you somewhere once you're in there 10 years or more. Okay, so Liv, you had others?
Yeah, here.
Libby's controlling the question, so
Sorry.
she's setting me up here.
Okay, let's see here.
Still looking.
The answer.
We've got lots of, some we've answered, and there's lots of questions, so forgive us. She's grabbing a couple here. Okay, you have to invest in the Qualified Opportunity Zone property after purchase the same amount you invested in the purchase of the property. Well, that's, I just read it exactly as the writer of the question said it, but I think what they're saying there, do you have to invest the whole thing? No, you only have to invest the gain. So it says again, do you have to invest into the OZ, the occupied zone or qualified zone property after purchase the same amount you invest in the purchase of that property? No. It's only, the only thing you have to do to have the deferral is invest at least the gain amount. Now, if you didn't invest at all, then you pay tax on the lesser of the amount you didn't invest or the gain, lesser of those two. So if you had gain of $200 or 200 million, whatever it is, and you invested 3/4 of that, that's where your deferral is on the 3/4. Liv?
No, I agree.
Okay. Did you say, there's another question, did you say there's no identification requirement of a target of qualified zone property? And yes, that's right, there is none. So let me say it again. The question is asking, do you have identification? No. I mean, you just got to make sure you invest timely, but unlike the 1031 rule where you have to identify under the 1.1031K regs, you have to identify timely and properly for 1031 on a non-simultaneous exchange with the 45-day rule. You don't have that under the qualified opportunity zone. Just get your money into the qualified zone or your client's money timely, and then you can have the benefits of the deferral and potential exclusion. All right, I guess one more here. Okay, it says, if I invest my gain today in a qualified opportunity zone, which then invests in new construction of some facilities over the next 10 years at a rate of 1 per year, and then I sell the qualified opportunity fund investment in year 11 for a significant capital gain generated, will all the gain be excluded from taxes? I think the answer is yes, because you are investing in the fund. The fund can do a lot of different things, but as long as you're in that fund, you're 10 years or more, you're fine. The fact that it didn't invest all of it, and there are all kinds of rules on the qualified opportunity fund as to 90% rule investing, if you read some of the regs on it, and so on, and there's time for working, or amounts for working capital, and so on. So you don't have to make sure it was invested in a, let's take this, a physical piece of real estate for all 10 years. As long as you're in the fund for 10 years, I think you're there. And speaking of there, I think we're there. So I encourage you to send Libby. Don't send it to me because she's going to answer them all. No, either one of us. Send us any questions that you would like. We're happy to try to answer them. And I admit to you, we're learning as we go too. But I think, again, the Qualified Opportunity Zone Fund has some wonderful advantages, but it's not the panacea. It's just another tool.
And I just want to add one more thing on that last question, on the 11-year, the question about the 11 years. Just remember that we need to still draw that line on that diagram. So I assume that when you're talking about capital gain generated, you're talking about from this new investment, not the prior,
right.
Not the prior deferral, which would still have an exclusion of the 15%, but you'd still owe the 85% from the prior deferral. So I just wanted to add that. Perfect. Anyway, thank you all very much, and you can certainly email me questions. I will forward them on. I'm kidding. But happy to try to. We'll both be happy to try to answer.
Mark and Libby, thank you so much. I did see a comment float up that asked if you could put your contact information back up, and I don't recall if the last slide had that, but we will make sure when we send out a recording of today's presentation that they know how to contact you. Thank you again very much for your time, talent, and expertise. We really appreciate it. And as the audience, I think is evident by all the questions, they really appreciated the content too.
Our pleasure. The check's in the mail, I know.
The check is in the mail. And to those that joined us today, thank you so much. And we look forward to seeing you on a future CCIM Institute webinar. Thank you and have a great day.
Thank you.